The precedent here is very simple. You have a federal law enforcement official engaging in federal law enforcement action. That's a federal issue. That guy is protected by absolute immunity. He was doing his job.
That was Vice President JD Vance Thursday from the White House briefing room, defending the actions of the ICE agent who fatally shot Renee Nicole Good in Minneapolis earlier this week. Joining us now is CBS News legal contributor and Loyola Law School professor Jessica Levinson. So, Jessica, what does absolute immunity mean?
So it means exactly what it sounds like. I mean, we last talked about absolute immunity when it comes to presidential immunity. There was, of course, that big Supreme Court case that if the president is exercising his core presidential functions, those functions given only to him by the Constitution, then he's absolutely immune from criminal liability. That's not the standard that we use when it comes to federal officers who are performing their duties. The standard instead is something called qualified immunity. In that case, you are, in fact, protected from civil liability. This is about civil suits, not criminal suits. You're protected from civil liability unless you can show that there was a violation of a law and that that law was clearly established. So it's a difficult hurdle, but there's not absolute immunity in this situation.
So how is this something that could potentially come up in court, or would it not? Because per your point, this would come up maybe in a civil case, but not criminal.
So it could come up in court in a civil case. There's something called a Bivens claim. And essentially the claim from the family's estate could be that in this case, that the officer, in fact, used excessive force, that there was a violation of Fourth Amendment rights, and that that violation was clearly established, for instance, by other case law. Again, you'd have to show in this case that the officer used excessive force, meaning, and the defense here would be that he would say a reasonable officer standing in my shoes felt that there was an imminent harm for great bodily injury or death, either by the officer or someone else. That would be the defense. But the way it would come in is a civil case. And obviously it would be a defense that the officer would bring up.
Oh, Jessica Levinson, we appreciate you shedding light on that. Thank you.